The Convention on the Rights of Persons with Disabilities. Did you know that there are around 1 billion people with disabilities in the world? The Convention on the Rights of Persons with Disabilities is an international human rights treaty of the United Nations intended to protect the rights and dignity of persons with disabilities. It is designed by representatives of the international community to change the way people with disability are viewed and treated in their societies. The Convention seeks to change the perspective of viewing persons with disabilities as objects of charity, medical treatment, and social protection towards viewing them as subjects with rights, capable of claiming those rights and making decisions for their lives based on their free and informed consent, as well as being active members of society. It was signed on March 30, 2007 and entered into force on May 3, 2008. It is the first UN human rights treaty of the 21st century. It was one of the most quickly supported human rights instruments in history. The purpose of the treaty is to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for the inherent dignity of all persons with disabilities. There are 8 principles embodied in the Convention. These are respect for inherent dignity and individual autonomy, non-discrimination, full and effective participation and inclusion in society, respect for difference and acceptance of persons with disabilities as part of human diversity and humanity, equality of opportunity, accessibility, equality between men and women, and respect for the evolving capacities of children with disabilities, and respect for their right to preserve their identities. The first principle of the Convention is respect for inherent dignity, individual autonomy, including the freedom to make one's own choices and independence of persons. The Convention eliminates barriers to enable the persons with disability to participate fully in the society. They are part of the community and they have the same rights and obligations in the society. The second principle is non-discrimination. States parties recognize that all persons are equal before and under the law and are entitled without any discrimination to the equal protection and equal benefit of the law. The third principle of the Convention is full and effective participation and inclusion in society. States parties recognize the equal right of all persons with disabilities to live in the community with choices equal to others, taking of effective and appropriate measures by states parties to facilitate full enjoyment by persons with disabilities of this right and their full inclusion and participation in the community. The next principle is respect for difference and acceptance of persons with disabilities as part of human diversity and humanity. Disability is not inability. Persons with disabilities should not be treated differently because of their situation. They must be respected and accepted as part of the human diversity. Let's move on to the fifth principle, which is equality of opportunity. States parties recognize the right of persons with disabilities to work on an equal basis with others. This includes the right to the opportunity to gain a living by work freely chosen or accepted in a labor market and a work environment that is open, inclusive, and accessible to persons with disabilities. Let's tackle about the sixth principle, which is accessibility. Under Article 9, the Convention stresses that persons with disabilities should be able to live independently and participate fully in all aspects of life. To this end, state parties should take appropriate measures to ensure that persons with disabilities have access to the physical environment, to transportation, to information and communications technology, and to other facilities and services open or provided to the public. Let's go to the seventh principle about equality between men and women. States parties recognize that women and girls with disabilities are subject to multiple discrimination, and in this regard, shall take measures to ensure the full and equal enjoyment by them of all human rights and fundamental freedoms. The eighth principle is about respect for the evolving capacities of children with disabilities and respect for the right of children with disabilities to preserve their identities. States parties shall take all necessary measures to ensure the full enjoyment by children with disabilities of all human rights and fundamental freedoms on an equal basis with other children. Children with disabilities shall be registered immediately after birth and shall have the right from birth to a name, the right to acquire nationality, and the right to know and be cared for by their parents.
Now that we know the underlying principles behind the Convention on the Rights of Persons with Disabilities, let us now take a look at how Philippines brought these principles into its domestic sphere, and how it significantly affected the rights of persons with disabilities. The Philippines ratified the Convention on April 15, 2008, and it was entered into force on May 3, 2008. Even before we ratified the Convention in 2008, we already have Republic Act 7277, otherwise known as the Magna Carta for Disabled Persons, which was enacted in 1992. This law granted several rights and privileges for persons with disabilities or PWDs, guided by the policy to give full support to the improvement of their total well-being and their integration to the society. Then in 2008, as earlier stated, the Philippines ratified the Convention on the Rights of Persons with Disabilities. Then later on 2010, Republic Act 10070 was enacted, introducing amendments in Republic Act 7277. This was in furtherance of the interest of PWDs and is our commitment to the Convention. This established an institutional mechanism to ensure that the implementation of the programs and services for PWDs are being done. Then later in 2013, Republic Act 10366 was enacted, enhancing and promoting the political rights of PWDs. In this law, the COMELEC was authorized to establish polling precincts for PWDs. And then lastly, in 2016, Republic Act 10754 was enacted, introducing amendments to Republic Act 7277. This expanded the different benefits and privileges that our PWDs are receiving. Now that we know all these legislations in the Philippines, you might want to ask, why do we have a law on the rights of PWDs even prior to the Convention? Well, the answer is in our Constitution. Article 2, Section 2 of the 1987 Constitution provides that the Philippines adopts the generally accepted principles of international law as part of the law of the land and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. Note that the furtherance of the rights of persons with disabilities is enshrined here. Our laws and policies should be in the promotion of equality. In addition to that, the Constitution forbids discrimination as enshrined in Article 13, Sections 1 and 2. It mandates that the Congress shall give highest priority to the enactment of measures that protect and enhance the right of all people. It also provides the promotion of social justice, which shall include commitment to create economic opportunities based on freedom of initiative and self-reliance. Now, with all these constitutional mandates and enacted laws, let us now take a look at how significant the Convention is applied to the Philippines and to the rights of persons with disabilities. In the 2010 Census Population and Housing Report, of the 92.1 million household population, there are around 1.4 million who had a disability. That is about 1.57% of the population, and a great number of them experience discrimination. They are likewise denied opportunities to work and participate fully in the society. This is where the Convention comes in. The Convention serves as an instrument to ensure that they are not discriminated against and can exercise their rights on an equal footing with others. With the creation of the convention follows the creation of different organizations and committees that will provide an adequate support and researches on how to implement the provisions of the convention to achieve its goals. Different guidelines for the promotion of an inclusive environment were likewise issued to help not just the Philippines but the different states as well. To illustrate the significance of the convention in the Philippine setting, let us take a look at the following examples. First, in education. We know for a fact that there's a large number of uneducated PWDs due to lack of trained teachers and facilities which would cater to their needs. To address this problem, the Committee on the Rights of Persons with Disabilities helps in the adoption of a policy entitled Inclusive Education. This policy was created together with the Department of Education, which encourages parents of PWDs to enroll their children in special education centers or schools nearest to their homes. Training programs in inclusive education was likewise developed for administrators and supervisors, and scholarship programs for special education teachers. Being a party to the convention gives us access to different policies and practices that promotes the literacy of PWDs. In terms of the rights of women with disabilities, being a woman alone carries inequality and lesser opportunities. Now imagine the discrimination being faced by women with disabilities. They are being discriminated upon based on gender and disability. The Philippine Alliance of Women with Disabilities, or PAWID, which is a subset member of the Organization of the Philippine Coalition on United Nations Convention on the Rights of Persons with Disabilities, advocates specifically for the rights of women and girls with disabilities. They likewise recommend to our government different action plans to reduce the inequalities and discriminations being faced by women with disabilities. But what can we conclude from these examples? It is that being a party to the convention shows that we are no longer alone in the battle against discrimination and inequalities, because there are different entities that will help us lessen, if not eliminate, the discrimination and equality against PWDs.
Let us now go to the impact on the international community. Many countries who are members of the United Nations have adopted the provisions of the Convention and are looking at their laws and policies to incorporate the Convention into their local laws to promote and protect the rights of persons with disabilities. As stated previously, the Philippines, as one of the members of the United Nations and as one of the signatories of the Convention, have amended its domestic laws on persons with disabilities in order to bring it into line with the Convention. Other examples of countries which have adopted the Convention include Cambodia and Estonia, as we will see later in this presentation. Criticisms on the Convention. The main criticism that we will discuss involves the interpretation of some of the provisions of the Convention, particularly Article 12 and 13, among others. This criticism is discussed in a research paper published in World Psychiatry by George Smuggler. Article 12 of the provision provides that persons with disabilities have the right to recognition everywhere as persons before the law. This is in line with the purposes of the Convention to promote, protect, and ensure the equal enjoyment of all human rights and freedoms by persons with disabilities, in an equal capacity to those without disabilities. Now, we must remember that under the Convention, persons with disabilities are not only persons with physical impairments, such as deafness or blindness, but also includes people who have mental disabilities and intellectual or sensory impairments. Now, recent interpretations issued by the UNCRPD Committee lead to an insistence that involuntary detention and treatment of people with mental health or psychosocial disabilities are prohibited. The committee's general comment on Article 12 of the Convention includes, and I quote, The denial of the legal capacity of persons with disabilities and their detention in institutions against their will, either without their consent or with the consent of a substitute decision maker, constitutes arbitrary deprivation of liberty and violates Articles 12 and 14 of the Convention. Basically, the committee is arguing that people with mental disabilities should not be put into mental institutions without their consent, or by only obtaining the consent of a family member who gives the go signal to detain their mentally disabled relative. According to the committee, such is a denial of the legal capacity of persons with mental disabilities. Another statement by the committee is directed towards Article 14, which is a provision on liberty and security of person. It states, and I quote, "The committee has called on states parties to protect the security and personal integrity of persons with disabilities who are deprived of their liberty, including by eliminating the use of forced treatment, seclusion, and various methods of restraint in medical facilities, including physical, chemical, and mechanic restraints." An international group of clinicians now criticizes the committee's interpretation. They say that the rights of others, the family, and the public will be threatened and will ironically lead to a stigma on mental illness. Basically, they are saying that people with mental illness will obviously not give their consent to be detained and treated in facilities. Hence, if we were to be required to get their consent first before detaining them in mental health facilities, its effect would be that people with mental illness will refuse to be treated in facilities. This effect is not beneficial to them, their family, and the public. We now go to another criticism which is anchored on forensic practice. The committee's interpretation of Article 12 in connection with Article 13 has implications for forensic practice, including a possible prohibition of the mental condition defenses. What are those? It is unfitness to stand trial and the not guilty by reason of insanity. Why? Because those defenses must be disability neutral. Stated simply, there might come a time when the mental condition defenses cannot be used by persons with mental illness. Why? Because the committee is saying that such persons must be treated equally like persons who have no mental disabilities. In effect, mentally disabled persons will be required to stand trial despite their inability to do so, and insane persons cannot use the defense of insanity. John Dawson, a law professor and author of books related to mental health and mental capacity with regards to law, criticizes the committee's interpretation for failing to offer adequate guidance on how conflicts can be resolved should situations arise where rights articulated in the convention are in conflict. He states that balance should be settled between competing imperatives. So we should now ask the question, what should prevail, autonomy or the protection of the interests of a vulnerable person? He argued that denial of legal capacity to mentally ill persons does not necessarily mean a denial of human rights. For instance, are blind people allowed to drive? No. Why? Because blind people have visual impairment. To allow them to drive would lead to more harm to themselves and to the people around them. This is similar to a person with mental illness. Denying them of legal capacity is not a denial of their human rights, because it is for their own good and for the good of the public. Lastly, Dawson argued that it is not discrimination if we treat persons differently if there are relevant differences among them, even after adequate support is provided and reasonable accommodations are made. Despite the criticisms, there will always be a solution to prevent the misinterpretation and misapplication of the convention. This can be done by amending certain provisions which are inconsistent with the Convention. The Convention itself, under Article 47, envisions a less arduous process by which amendments can be made. Any state party to the Convention is allowed to propose an amendment which can be considered with the support of 1/3 of states and adopted by a vote of 2/3. Let us now go to news about the Convention. The first one is titled Cambodia Revised Flawed Disability Bill, published on April 27, 2021. The Cambodian government is enjoined by the Human Rights Watch to revise a draft disability law to ensure equal rights for people with disabilities in accordance with international human rights law. A copy of the draft law was obtained by the Human Rights Watch. The draft law purports to create a legal framework for the rights of people with disabilities, but it fails to adopt a human rights-based approach. It uses language that reinforces stigma against people with disabilities rather than ensuring equal access to education, employment, transportation, social and legal services, and independent living. The Human Rights Watch said that the bill has stigmatizing language which would marginalize persons with disabilities. The stigmatizing language mentioned included terms such as disorder, damaged, and malfunction, implying that a disability needs to be cured or fixed. With regards to education, portions of the bill will promote segregation instead of providing inclusive education. Regarding protection from sexual violence and harassment, the bill uses vague language and does not offer procedures to actually confront sexual violence and harassment. Finally, the Human Rights Watch stated that the Cambodian government should draft a law that is consistent with the convention. The second article is the closing remarks by the Special Rapporteur on the Rights of Persons with Disabilities at the Dialogue on the Implementation of the Convention of States Parties with the UN. Basically, they are saying that persons with disabilities must not be left behind in the COVID-19 response and recovery, and must be placed at the center of the response. It highlighted the fact that even without a pandemic, persons with disabilities are already disadvantaged when it comes to access to healthcare, education, employment, and community participation. When COVID-19 pandemic hit, this situation was made worse. Hence, special consideration must be made in favor of persons with disabilities. Last news. UNCRPD Committee reviews Estonia, published on April 2, 2021 on the European Union of the Deaf website. When the CRPD Committee held its virtual session from March 8 to April 1, 2021, only one country was under review, Estonia. This was the committee's first assessment on Estonia's implementation of the convention. Estonia ratified the convention in May of 2012, and the European Union of the Deaf worked closely with the Estonian Association of the Deaf to ensure that the issues related to the implementation of the convention in Estonia for deaf persons are properly addressed during the state party review. The EUD encouraged the Estonian Association of the Deaf to be an active player during the review and collaborate with other relevant partners to ensure that deaf people are not left behind during the process. The committee published the concluding observations and recommended Estonia to ensure access to sign language interpretation and speech-to-text service for deaf and hard-of-hearing persons in all areas of life. That is all the news that we have for today. Now let's go to the fun facts. Did you know that the convention was modeled after the Americans with Disabilities Act? This act embraces the rights and dignity of all people with disabilities. Also, the Convention on the Rights of Persons with Disabilities was written mostly by ordinary people with disabilities. Did you also know that over 15% of the world's population live with disabilities? Now that you all know this, we should now remember that disability is not inability. Treat all people with compassion and respect. This is Group 5 reporting. Thank you so much for watching.